Good afternoon and welcome to another Lunch and Learn episode. Today we will be discussing your rights and recourses when it comes to maintenance matters. So what are your rights? What can you insist on? What can you expect from courts? Your rights and recourses when it comes to maintenance. So we will discuss your rights as the complainant as well as the respondent in maintenance situations during the whole court process, right from the beginning, from laying a charge right through to the end, how you are treated, what are your rights. What also we will be discussing, what can you expect from the personnel at court? How should you be treated? What can you expect from that? What is it that they need to do, and so forth. We will also be addressing what the complaints procedure is, the hierarchy of complaints, but we will be dealing with that in a future webinar, probably 2 or 3 webinars on, specifically a whole webinar on how to deal with complaints, how to complain and whom to complain to, but we'll address that shortly and just a short discussion during this webinar as well. We will be making reference to the DOJ Code 26 of 2015, explaining to you what is that DOJ Code, what we're referring to, and how it should be utilized and why is it there. And then Advocate Raters will be joining me for a short discussion on the service delivery charter. Just some logistics, as you all know by now, if you have registered on our website, you would have received the link. During the link on the link, you would have access to this website together with a copy of the handout as well as the slides, and then most importantly, the resource and templates tab, where you would have access and able to download some of the documents that we will be discussing during this webinar, specifically the DOJ Code. I will put on there so that you can download that, as well as the service delivery charter that you can also download if you have access to that and if you have registered. To all the attendees watching on our social media platforms, very welcome. If you would like to have access to the documentation, the slides and the handout and so forth, please do register for the webinars in future on our website. The registrations there is free, so you can register there at any time for our future webinars. And there is also the tab right at the top for our previous webinars. So if you have missed some of our previous webinars, have a browse there. We are dealing with, since the beginning of the year, of any and all aspects of maintenance, and to educate and create awareness for that. So, right, let's just jump right into it. So, if one thinks about maintenance, then the first thing that comes to mind, and we have a Facebook group and we've got WhatsApp groups as well. The first thing, once we've asked the members of our Facebook group, explain to us what is maintenance in one word, and about 90% said that it is frustrating. The whole process of claiming maintenance is a frustration of note. So I thought it might be a good idea just to give you some background information. The Maintenance Act came into operation under Act 99 of 1998, way back when. So that is quite an old act, but in terms of legislation, not that old. Subsequently, after that, there was a case in 2002. That's a couple of years after it was enacted, the case of Ballantine versus Ballantine. And in that case, in the Ballantine case, already at that stage, the court found that despite the good intentions of the Maintenance Act, the logistical difficulties in maintenance court mean that the maintenance system does not function effectively. So already in 2002, it was recognized by the court personnel or the judges that there are certain limitations and some drawbacks in the whole maintenance system. Subsequently, after that case came out in 2002, there was the South African Law Reform Commission. There was a discussion paper, paper 28, that actually reviewed the Maintenance Act. That was Project 100, and that was done in 2014. After that, there was a Maintenance Amendment Act that was based on the recommendations of the South African Law Reform Commission, and that was enacted by Act, the Maintenance Amendment Act 9 of 2015. And only a couple of years later, in 2017, there was an amendment to the regulations. So if one thinks about it now from 1998 up until now, yes, most definitely there needs to be some changes. It was already recognized in 2002 in the Valentine case that the maintenance system does not function properly or effectively. And at this stage, there is paper 157 at the South African Law Reform Commission, of which I did my submissions to them, and I engaged with them on quite a number of workshops pertaining to the changes or proposed changes to the maintenance legislation to make it more efficient, more dynamic, more fluid, to adapt to certain circumstances, because we identified that there might be some loopholes and some problems with the current Maintenance Act. But yes, it is still in process. It is open for public participation. If any of you would like to have a copy of paper 157, the discussion paper, please just drop me an email and I'll send that off to you. Apart from that, we also have the National Strategic Plan. And specifically in that plan, if one looks just as a general introduction, maintenance was not mentioned quite a number of times, like in the previous strategic plans. But the only reference that I could find in the 2001 or 2021 to 2025 strategic plan was that maintenance and other issues related to children are of major interest to the department. Now, that's the Department of Justice. It goes further to say that while major improvements have been done in the processes related to maintenance applications, the department plans to improve the speed and efficiency in finalizing maintenance orders. Now, for all practical purposes, and we know that, and everybody that has attended maintenance court know that this is basically just lip service. So this is where these type of lunch and learn webinars come in, because education is knowledge. You should know what is your rights and your recourse. What can you expect from maintenance courts? Because if you do not know, then you would not know how to say, but you know what, one of my rights have been infringed. So you have to know, and you have to become knowledgeable on what your rights are in order to enforce them. In my view, it should be a two-prong approach. It should be a top from a top to bottom and a bottom to top approach. Number one is that, yes, obviously the government needs to change. They need to change the legislation in order to make it more accessible to people attending to maintenance courts. But the people attending to that, or the government structures involved, like the South African Law Commission and the legislator, they have to know, and they have to realize that on ground level, those people standing in the queues wanting to claim maintenance also have a say, because most of these people sitting in these high-ranking offices, the glass towers, they have never been to a maintenance court. They do not know what it is to stand in a queue, to wait for 7 hours just to get to the front of the queue, and then the matter gets remanded. Those are all things that the general public needs to bring to the attention to the legislator and to the South African Law Reform Commissions. And this is why we want to educate the people and create awareness of what your rights are. Because only if once you know that your rights have been infringed, you can complain through the necessary channels, and then the government would know, the legislator would know that there might be certain problems, and they can address that problems accordingly. So in my view, it should be a two-pronged approach, from bottom down and from the top to the bottom. And this is where I appeal to everybody listening, that if you do have a problem, please make it known. Just don't sit around and say, all right, you know what, the problem is going away, because the problem is probably not going to go away. And if you feel like that, then there is probably 1,000 other people feeling exactly the same. So speak up and use the complaints procedures and the structures available for that. When it comes to rights, there are basically two fundamental rights. We call it the first generation rights, and we call it the second generation rights. Remember, we're talking about the rights and recourses specifically when it comes to maintenance. But just as a general overview, the first generation rights are usually called the negative rights. That is rights that are meant to protect the public against violations and the abuse of the state or any of those powerful entities. Examples of these type of rights might be the freedom of association, freedom of speech, freedom of religion. Those are all first generation rights, the negative rights. On the flip side of that, that is the positive rights. Those are usually the socio-economic rights, which require the state to provide something. The state needs to do something. Like, for example, the right to healthcare, the right to sufficient and adequate food and water, and the right of access to courts. And then, of course, there is Section 28 that deals with the rights of the child. And we've been making reference to that quite a number of times. So I urge you guys to read Section 28, where it says that every child has the right to family care or parental care, or to appropriate alternative care, and to be removed from, and not to be removed from, a family environment. They also have the right to basic nutrition, shelter, basic healthcare services, and social services, to be protected from maltreatment, neglect, abuse, and degradation, and also to have a legal practitioner assigned to them if they are represented in a matter, for example. And we'll come back to that at a later stage. And then Section 2 speaks about the child's best interest of paramount importance in every matter concerning a child. And one would know, and as it's common knowledge, that once we deal with a maintenance matter, there is a child involved. There is a minor child. It might also be a major child, or a child that is older than 18. But yes, there are children involved. So Section 28(1)(d) or Section 28(2) says that it is paramount importance. The best interest of the child always needs to be to the forefront. Having said that, then there's also the stipulation of Section 15 of the Maintenance Act that deals specifically with the duty of the parents to support their children. So those are a basic right. Section 15 says that a maintenance order for maintenance could be directed to a person that is legally liable to maintain a minor child, or a child that is not self-supporting, and that is just an enforcement of the common law duty of the child's parent to support that child. And then Section 15(2) goes further to say that, you know what, the extent of this support includes proper living and upbringing, and it also includes for the provision of food, clothing, accommodation, medical care, and education. So those are basically the basic rights enshrined in the Section 15 of the Maintenance Act. Process of complaints. I want to start off there and then moving backwards, because we'll come back to this at a later stage. One needs to distinguish that there are two groups of complaints. If you are in court, if it is done in court and there's a magistrate, you have been sworn in to testify and to lead evidence in court, that is a judicial discretion. If the magistrate makes a ruling or an order and it's done in court, you were sworn in, giving evidence and so forth, and that's usually a Section 10 inquiry, then that matter does not follow the normal hierarchy process. Because it was done in court, the correct procedure there would be that an appeal or a review procedure needs to be followed because it was done in court. For all the other processes that needs to be followed, the submitting of the documents at court, being treated rude, coming to court and the doors are closed, or there's no one there, there's no maintenance officer, and so forth. Everything that is not done in court follows a normal hierarchy of a procedure that needs to be followed in order to lodge your complaint, which we will deal with shortly. Before we get to the whole process of the complaint, remember now it's not for processes in court, because that's the appeal and the review. In each and every magistrate court in South Africa, there is a board similar to the one on screen right now, and that is basically the management structure, the details of the management in a specific court. And that would include the court manager, the area court manager's details, the director of court operations, as well as the regional head. Those are the people that you can contact if you do have a complaint. That is the reason why the boards are there. So my suggestion would be that as soon as you go to the maintenance court and you need to file your application for maintenance, take a photo of that, because during this whole process, there might be a need that you need to contact one of those people, or one starting off with a court manager and then ending up at the regional head, in order to escalate your matter, or if you do have a complaint being treated unfairly and so forth. So please do take a photo thereof, keep it on your phone, print it out, put it in your file that you have at home with all your documents in there. So just in short, the procedure would be the complaints procedure. The first line of call would be the court manager. There's no need, because you don't escalate it further to the higher up person in the hierarchy system, because they would just refer it back to the initial one. So follow the process. You still start off with the court manager. Then you go, if you do not get any joy from the court manager, you escalate the matter to the area court manager, and then to the regional head, and then to the national complaints manager. Or you could also, if you don't have any joy of any of these structures and they do not attend to your query, or they ignore you, or they ghost you, then you could actually ask the public protector to also get involved. Explain this in some great detail in a webinar coming up shortly. That is basically just the process of complaints. So if one looks now at what are your rights when it comes to maintenance matters. Now, I've done this structure to indicate what are processes that are not done in court and which are in court. And I've divided it up between 4 phases. The first phase is the application phase, the investigation phase, the Section 6 inquiry phase, and then the formal Section 10 inquiry phase, which is done in court. And remember, if it's done in court, then you don't have the normal hierarchy of complaints like the court manager, the area court manager, and so forth. The formal Section 10 phase would, the correct procedure would there be that an appeal or a review is lodged if you're not happy with the decision of the magistrate. So those are basically the 4 phases that we will be addressing, and what rights would there be. The application phase, if we start off there, it's basically what documents are needed, the opening of the file, preparation of the file, and the procedures once you go to court and you file those documents. Those are usually the first applications. It could also be a variation order for increase or decrease, and so forth. But we'll go through that in a couple of minutes in the next couple of slides. The next phase is the investigation phase. That is basically explaining the duties of the maintenance officer as well as the maintenance investigator. This is where all the documentation needs to be compiled to be put forward to the maintenance officer to make an informed decision and engage into meaningful conversation with the parties when they go for a Section 6 inquiry, establishing what are the needs of the children and also discussing and evaluating the means of parties. That is the investigation phase. Now we turn to the Section 6 inquiry phase. Again, the role of the maintenance officer should be clearly defined. What happens in paternity issues, how that is dealt with. If you are being bullied by a legal representative during a Section 6, how do we deal with that? Postponements, unnecessary postponements. The maintenance court should not be a court of postponement. They should strive to expeditiously attend to the maintenance matter, because there are children involved. And Section 28 says of the Constitution says that the needs of the children are of paramount importance. Then turning to the Section 10 inquiry, the Office of the Family Advocate might become involved, as well as the maintenance officer. What would happen if there's no investigations done, if the court was not fair, the appeal procedure, and so forth. Now, these are the 4 phases that we will be discussing, and we'll do that by making reference to what we know as the DOJ Code. That is basically a guideline issued by the Department of Justice to all the government departments dealing specifically with family courts and maintenance matters. Now, we shortly refer to this as the DOJ Code 26 of 2015. That is basically, like I said, it is not legislation. It is basically just a framework under which the DOJ operates that they give out to the clerks and how they should manage certain maintenance matters. So we will be referring to that throughout this presentation. A couple of pointers, just as an introduction to the DOJ Code, section 3.1 or paragraph 3.1 says that it should be made available and it's applicable to all maintenance courts right throughout South Africa. And very important is also paragraph 4.1, where it says that if they do not abide by these codes or these rules or directives in the DOJ Code, that they might land up into trouble and there might be disciplinary hearings as a result thereof, punitive actions against certain maintenance officials that do not abide by this code. Section or paragraph 6.1 states that a hard copy thereof should be available to all the clerks and all the maintenance officers and all the maintenance personnel in each of these courts. Is it done? No. I found that in many courts, they do not even know the existence of the code. So in the next couple of slides, we'll be going through some of the scenarios that I've identified that might cause problems in the whole maintenance setup. And I've identified a couple of those, making specifically a reference to certain acts, obviously the Constitution, the Maintenance Act, the maintenance regulations, as well as the DOJ Code. Obviously, it's not an exhaustive or closed list. There could be thousands more, but due to time constraints, not keeping you for the next 6 hours, discussing all the different scenarios or the problems that might arise. I've only identified a couple of those. The slides are available for download, and where we discuss most of those. So if I skip one or two, then it is available. It's also available in your handout, and you are also most welcome to download the DOJ Code, which is available on the website. So if we start off right at the beginning, we talk about the irregular court hours. We find that many of our complaints that we receive is that the maintenance courts only operate on certain days or certain hours of the week. Now, this is highly irregular because Section 34 and Section 3 of the Maintenance Act and Section 34 of the Constitution grants everybody the right to have access to courts where their dispute could be resolved. Section 3 also mentions that every magistrate court within a specific geographic area should be operational as a court for purposes of that act. And also, the act also makes provision for certain court hours that the courts would be open from at least 9 o'clock to 4 o'clock each and every day. So if you do have a problem with regards to the court hours, then you should follow the hierarchy process, like I explained previously. And also bear in mind that we will be discussing the exact way and the precise procedure to follow for complaints in a later webinar. We will give you a template thereof as well. But for now, if we make reference to the hierarchy process, like we explained, you first report that to the court manager and then the area court manager and so forth. That is the complaints procedure. Do not skip one of the steps because they will just be referring it back to the other person that needs to attend to that matter before it's escalated to the person higher up. Let's just identify a couple of more problems that you might encounter in the application phase. Rude personnel that you have to report to the area or the court manager. If there's no personnel in the maintenance office, yes, obviously, if you get there and there is no personnel to assist you, then you have to go and report the matter at the court manager. And you could also ask for subsistence and allowance in terms of Section 11 and Regulation 5 of the Maintenance Act. So if you've gone to court and you had to wait for a long time, you had to take off work, put in leave and so forth, then you are entitled to ask for subsistence and travel allowance for attending court and nobody helped you. If you are asked to complete the form and just hand it in at court and then wait till they call you, there's specific provisions in the DOJ Code, paragraph 15.2, where it says that the clerk of the maintenance court must assist you to complete the file and to complete the forms. So if you are just, you blocked at the entrance of the court, saying that you have to take this form and fill it in and bring it back, you can actually insist that the maintenance clerk assist you to complete the form. We also found that in some instances, the maintenance clerk would do an evaluation and say, you know what, you do not have a case. That's specifically if there is something like spousal maintenance that you want to claim because it formed the basis of a higher court or a regional court divorce proceedings. Then some of the clerks would just turn you away and say, but you know what, you do not have a claim, or you have to come back in a month's time, or whatever the case might be. The DOJ Code speaks very clearly in terms of paragraph 15.3 that the clerk of the maintenance court is not entitled to make any decisions on the merits or the demerits of the application, but the responsible person in this matter would be the maintenance officer. If you do not have an ID and you are turned away, then in terms of paragraph 15.1, it very clearly states that no complainant may be turned away due to the unavailability of an identity document or a birth certificate. In fact, the code prescribes that the clerk actually needs to assist you in obtaining a birth certificate or an identity document. So if you go to court and they turn you away just because you do not have an ID or a birth certificate, show them section or paragraph 15.1 of the DOJ Code that they are not allowed to turn you away. If they do, please lodge a formal complaint then at the court manager. Files then went missing. We see that quite often. That also speaks to proper record keeping. That is mentioned in the Maintenance Act, as well as paragraph 31.6, where it says that the clerk of the court, it's their responsibility to keep a complete record of the movement of the file. So there should be no issues with regarding to files that went missing. If the file gets handed over to the maintenance officer or to court or even to the maintenance investigator, the maintenance clerk is tasked to keep a movement of those files. We already spoke about the forms that you need to get at the security. The duties of the maintenance officer not being done. If you do have a problem with the maintenance officer, that it's taking forever and there's unreasonably delays, reference made to paragraph 16.2. Where it's the responsibility of the maintenance officer to see to that all the information is on that file, and all the documentation pertaining to your maintenance matter must be on that file, and they have to decide if it is sufficient to proceed to institute proceedings in terms of section 6. So there's some homework on your side that you have to do, but it's also the sole responsibility for the maintenance officer to make sure that all the documents are on file. So if it is not on file, then it is their responsibility, and they have to see to that even before the matter goes to a section 6 inquiry. If the matter takes too long to investigate, remember now the responsible person in this whole process is the maintenance officer, and they delegate certain tasks to the maintenance investigator. And if it takes too long, then most definitely you can complain. It is your right to complain to the court manager, and following the hierarchy process. Making also reference to paragraph 17.1, where it clearly says that upon receipt of the application form of the complainant, the clerk of the maintenance court must give that file to the maintenance officer, who must expeditiously investigate the complaint. And the maintenance officer needs to give direction and instructions to the investigator with regards to getting the banking statements, getting pay slips, and so forth. We've discussed the maintenance investigator that's taking too long. That is reference being made to paragraph 17.6. Other issues that might occur, or rights that might be infringed if a file is incomplete or it's not right to proceed. Reference being made to paragraph 17.8, where it says that the maintenance officer must ensure that the information concerning the assets, the income, and the expenses of the applicant and the respondent are contained into two separate bundles. So that needs to be filed in the court file, and that is the responsibility of the maintenance officer. It is We see that in practice, that it is expected from the complainant to make the necessary court bundles. If you want to, you can do that, but there's no responsibility or there's no obligation upon you to do that in terms of paragraph 17.8 of the DOJ Code. If there's wrong procedures followed, reference 18.1, record keeping and so forth. It's paragraph 22.4 and paragraph 18.2 still speaks to the duties of the maintenance officer, where they have to give direction to the clerk of the court what subpoena to be issued, what process needs to be followed, because they cannot do all those. Some of the tasks are being delegated, but if it's not being done, then obviously the maintenance officer, being the responsible person, is the person that you need to complain to, and following the hierarchy of complaints process, start off with the court manager. A couple of things, I'm not going through everyone, that you can read on the screen. Documents handed in at court and not filed in the maintenance court file, which causes delays. DOJ Code is very clear about that. Turned away for complaints, no investigation done on the file. Yes, that is making reference to the Maintenance Act in terms of Section 7, 7.1 specifically, where the duties of the maintenance investigator is discussed, what they should do and what type of information they are allowed to gather on instruction of the maintenance officer, which includes the identification or the tracing of the person, as well as any documentation that needs to be done. And as well as what is the procedure, Section 7.2 of the Maintenance Act, how it should be done. If the respondent is not giving all the details before the court intervention, Section 8.1 says that a magistrate may, during or even before the inquiry, request the maintenance, or at the request of the maintenance officer, require any person to appear before the magistrate for examination of this financial affairs, and they must also give information regarding the financial position of the parties. And this we do not see very often in courts. The reason unknown, we do not know why they do not do that. Also, we're making reference to Section 9.1 of the Maintenance Act. If the maintenance officer accepted the case and they're busy investigating that, and they're busy with the financial inquiry in court, the court is allowed to, in terms of Section 9.1, to get any other person to court to appear in the maintenance court and give oral or written evidence, or to produce any book or document or statement pertaining to the financial details of either the complainant or the respondent. And we see that happening when the HR department is usually contacted and subpoenaed to appear in court to give testimony regarding the financials, the income of the respondent. Proper record keeping, that's Regulation 24.1. We've spoken about that. That it needs to be done and it should be recorded. So everything, what they should not just write on a piece of paper, it should be neatly recorded in the court file, what happened on a specific day. So make sure if you attend court that the maintenance officer or the maintenance clerk actually writes in the court file that you have appeared on that day, that you have waited up for a certain period of time, and this was the reason for the postponement. Regulation 24.1 clearly states that proper record keeping must be done. Accessing the file, yes, in terms of our constitution, paragraph 32 says that anyone has the right to access to any information held by the state or any information that is held by another person that is required for the exercise or the protection of any rights. So you would have access to your maintenance file. If the maintenance officer tells you that you're not allowed to see the contents, so that is the contents, it might be the financial details of the respondent, refer them to Section 32 of the Constitution, where it says that you are allowed to do that. We have been a number of other issues or problems that might occur if the respondent offers a lesser amount even before they appear to court. What is the procedure there in terms of the DOJ Code 25.4 paragraph? If a file goes missing, like we've alluded to that, if the court order is not signed, we've seen that in a number of courts where the maintenance officers sign the court documents on behalf of the magistrate. Now, in terms of the DOJ Code, in terms of the provisions of the Maintenance Act, to be a valid court order, it needs to be signed by a magistrate. And a magistrate is the only official court official that is empowered to sign an agreement between the parties and then make it an order of court. It should not be the maintenance officer. That would be considered to be an invalid order. Another thing is also what we see that very often in the maintenance courts is that the maintenance officer is not available. There's no maintenance officer. They are either on leave, they are sick, or they are just not in the office. Again, the complaint procedure should start with the court manager and then follow the whole process, the hierarchy process that needs to be followed. Bear in mind that the DOJ Code in paragraph 33.4 says very clearly, where there is no maintenance officer appointed by the department, such complainant and complaint should be taken to the public prosecutor, who is deemed to be a maintenance officer in terms of section 4.1 of the Maintenance Act. So if you go to court and you get to court and there's no maintenance officer, they might not be there, then ask to speak to any of the prosecutors, because any of the prosecutors at that court is deemed to be maintenance officers in terms of section 4.1 of the Act. The argument by the respondent that he has other children to maintain, we've dealt with that. The respondent not appearing in court during the inquiry, what happens there? Obviously, we're referring to Regulation 3.2a of the Maintenance Act and Regulation 3.3, where it says that any person who fails to comply with the direction of the maintenance officer shall be guilty of an offence and liable for conviction to imprisonment for a period not exceeding 6 months. But that would be criminal proceedings. Does it happen in court? I've seen a number of courts that would actually issue a warrant of arrest for contempt of court if it seems that they have been properly served. The issue that most people deal with is unnecessary postponements when it comes to maintenance matters. I've seen, on average, that it usually takes 6 to 9 postponements before the matter is even attended to in a Section 6 inquiry, and even more postponements when you talk about the Section 10 formal inquiry. And that is totally unnecessary. And you are allowed in terms of Section 10.6b, where the court feels that there is a postponement and there's sufficient grounds that the matter should be postponed, and that you as the complainant may endure some hardship as a result of this postponement, then the court is entitled to make an interim maintenance order. So my advice to all the complainants out there is to, if there is more than one postponement, then refer the court and the maintenance officer to Section 10.6 of the Maintenance Act and then request for an interim maintenance order. Failure of a respondent to appear after having been properly served, we've dealt with that. Preparation on the court file not done, I'm not going into detail, we've dealt with that. You can read through that, and also making a reference specifically to the paragraphs 26 and 27 of the DOJ Code. This is now dealing with the Section 10 inquiry phase, which you should bear in mind that this happens in court. So if you are warned to be in court and you are not there, then a warrant of arrest could be issued. In some instances, a default order could also be made in the absence of the respondent if they do not appear in court. Still staying with the formal phase, the Section 10 phase, if the returns of service are not filed or not available. This is a very contentious issue because the maintenance clerks usually put the blame on the sheriff, that the sheriff did not send through the return in time, and so forth. Refer them to section paragraph 31(2) of the DOJ Code, where it says that the clerk of the maintenance court must ensure that the returns of service are filed in the appropriate court file. And they must inquire, the clerk must inquire within 7 days prior to the hearing, where is the return of service? So they need to phone up the sheriff of the court and find out 7 days beforehand. If they do not have a sheriff return at that stage, so that they could phone you and tell you it's not necessary to come to court because the respondent has no knowledge thereof, it could not be served, so that you do not waste your time in court. Returns missing, I've mentioned that they need to inquire if the file is missing. We spoke about the record keeping thereof. Investigation of the Office of the Family Advocate. Yes, in some instances, the maintenance court, in terms of section 10(1) big A, may ask with the assistance of the Office of the Family Advocate to investigate the welfare of the children if they are affected by a maintenance inquiry. Default orders, yes, we will be dealing in an upcoming webinar, we will be dealing specifically with default orders, reference being made to section 18(1) of the Maintenance Act. Long delays, we've spoken about that. Section 10(6) clearly says that the maintenance court shall conclude maintenance inquiries as speedily as possible and ensure that postponements are limited in number and in duration. And remember, we also, and I mentioned that previously, that you are entitled to ask for an interim maintenance order if there is unnecessary delays. If you are not satisfied, remember now the section 10 happens within the court, the maintenance court. So if there's a presiding officer, you will be sworn in, there will be testimony, and then there would be a ruling at the end thereof, or a verdict thereof at the end. So if you're not satisfied with the ruling of the court, then you should follow the appeal or the review procedure, which we will be dealing with later on. A couple of other aspects that also needs attention. If the transfer of the file, if you transfer the file from one court to another court, there is also provisions in paragraph 35, the procedure that needs to be followed when one file gets transferred. So if you move to a different province, how does that file need to be transferred? If they take too long, what is the procedure that needs to be followed? Read then paragraph or section 35.2 of the DOJ Code. We've spoken about if there's no maintenance officer available, you could look at that section. Service of documents. Just also on a side note, and that is why I brought that in there. If you have problems with documents that have not been served by the sheriff, then it is also allowed that the maintenance investigator, in terms of section 7(2) of the Maintenance Act, could be entitled or could be requested by the maintenance officer to serve or execute any process, any document of the maintenance court. Just in general, we've spoken about the transfer of files, legal representation. Anyone that appears in the maintenance court is entitled, in terms of section 10(3) of the Maintenance Act, to have legal representation present. I found that many of the complainants use that as a tool or use that as an argument to say, but you know what, the respondent can't pay maintenance, but he can afford attorney. And that would be the wrong way, because in terms of our constitution and our constitutional rights, everybody is entitled to legal representation. If a person lies under oath, and you have proof to the contrary, read section 34 of the Maintenance Act, where it says that any person who's requested by a maintenance investigator or a maintenance officer to give you information, and if they furnish willfully wrong or false information, knowing that it is not true, shall be guilty of an offense, and upon conviction might be liable for penalties and even a jail time. The same for the crime of perjury. If a person is disruptive in court, so if they scream or they disrupt the whole procedure, Section 35 that deals with offences also says that a person could be fined or imprisoned for a period of 1 year if they disrupt the procedure in or around court during that period of time. If you have been bullied by a legal practitioner, and yes, we know that that quite often happens, if you are being bullied, then it is well within your rights to report the matter to the Legal Practice Council that would investigate the matter and take that further. Now, in general, these are all the rights or some of the rights that we've identified that you might encounter or might be problematic. Obviously, there are many more. There are many more that could be identified, and it's well worth the read to download the DOJ Code and then read through that, because that would explain what is the procedures that need to be followed and what are the rights and what are the steps that you can insist that needs to be done. And that way, if you do have a valid complaint, that you can approach the court manager with that complaint to say, but you know what, these rights of mine have been infringed and I need to take the matter further. I need to escalate this matter so that it could be done correctly. A very interesting case of Mutimunye versus the Minister of Justice and Constitutional Development. It was an unreported case where Judge Hemstra actually made a ruling against the maintenance officer and the Minister of Justice for a maintenance officer that did not comply with the provisions of certain sections, and it caused damages for the complainant, this Anna Mutimunye, that went to court and she was not helped. She asked them for assistance, they could not help her, and that it was all with regards to a pension fund payout. And the court ruled against the Minister of Justice and Constitutional Development, and they offered, and the court ruled that a certain amount needs to be paid as compensation or damages for the maintenance officer that did not do the work properly. So there are some rights and there are some recourse that you could be that could be followed. Just to reiterate, is that the right procedure would be to start off with office. If you go to the office and you see the board at the maintenance court or the magistrate court with the people's names on it, first of all, the first port of call would always be the court manager. And you know what, don't be scared to knock on their door and to say, you know what, I feel that this right have been infringed. Having said that, it's also not necessary for any petty thing to complain. Remember now, the maintenance officers are overburdened with work as it is. But if you really do feel strongly that your case has been remanded or your file has been missing now for how long, and it's just postponement after postponement, anything that did not happen in court, because in court it's a judicial discretion that needs an appeal or a review procedure, but any of the other the administrative tasks of transfer of files, documents not on the court file, and so forth, then you are well within your rights to approach the court manager in order to lay a formal complaint. Remember, most of these complaints needs to be in writing, and my suggestion would be to get the email address of that person and then email it to them so that you have a paper trail. That is basically, in short, the procedures or just the rights and the recourse that you might have in a maintenance context. We will be dealing with exactly how to lodge your complaint. What is the wording? And we'll give you templates there on how to lodge your complaint to the area court manager, how to escalate that to the area court manager, the national, and so forth. We'll give you all the documentations, and that would be on our upcoming webinars, probably within the next month or so. Thank you so much for joining us. You are most welcome to make contact with us if you need any more information. If you need a copy of the DOJ Code, if you have not registered, please drop us an email and we'll send that through to you. You're also welcome to register for future webinars on our website, www.lunchandlearn.org.za, or you could also visit our website and click the link previous webinars, where you would have access to all the webinars that we've done since the beginning of the year, that you could watch there on our social media platforms as well. Thank you once again for joining. We hope you have a fantastic afternoon further. My name is Eugene Opperman. I'm a legal practitioner specializing mostly in family law matters, dealing with maintenance matters as well as domestic violence, as well as rights pertaining to children. Thank you so much for joining us, and we'll see you next week, same time, same place. Have a good afternoon.